Your Honor, counsel, ladies and gentlemen of the jury, it's July 23rd, about 12:30 in the afternoon. Vicki Hakala is in a hospital room at Hennepin County Medical Center in Minneapolis. It's an intensive care room. It's got gray walls and white tile, 2 windows in the room covered by thin white curtains. One window to the outside world, which stares at a brick wall across the opening, and the other window to the ICU nurse's desk. Vicki has been at the hospital for the most part 24 hours a day for the past 8 days since her husband Greg was hurt by electricity on July 16th. And the past 8 days have been a terrible ordeal for Vicki. Hope at first, grim reports from Greg's treating doctors, despair, resignation, and fear. A lot of fear. Fear for Greg, fear for herself, but mostly for her 2 daughters, Melissa, 15 years old, and Jenny, 12 years old. What will happen to them if their dad, Greg, dies? Greg Hakala is only 36 years old as he lays in the hospital bed this summer afternoon. He has a respirator going into his mouth. He's hooked up to monitors. The monitor, one of them gives off little beep, beep, beep. But Vicki doesn't notice this anymore. There's a strong, pungent smell of antiseptic in the room, which she doesn't notice anymore either. And you can hear the sound of the respirator breathing for Greg. But Vicki doesn't even notice that sound. She's used to it by now. Vicki is completely focused on Greg because, you see, despite the machine breathing for Greg, despite all of the heroic efforts to save her husband's life, her husband Greg is failing now and she knows it. Greg has never once been conscious these past 8 days. He's terribly brain damaged from when his heart was stopped by electricity back on July 16th. And his heart was stopped for way too long. He hasn't been able to even once talk to Vicki or give her any indication that he could hear her as she sat hour after hour, day after day with Greg in the hospital, talking to him. He hasn't given any indication that he could feel Vicki touching him as he lay there in the hospital bed, kissing him and hugging him. And now she's holding Greg's hand. She's rubbing his arm. She's touching him while his system's shut down. His heart is finally stopping, and the monitor straight lines. Vicki's able to tell Greg one last time, "I love you, Greg," and then he's gone. Ladies and gentlemen, this is a case about the tragic death of Greg Hakala, which I will prove to you was caused by the negligent conduct of defendant Stephen Gallus. Negligence simply means the failure to use reasonable care under the circumstances. It's that simple. And you're the judges of whether there was negligence in this case. I will prove to you Greg Hakala was killed because the defendant, Mr. Gallus, failed to use reasonable care, and he failed to follow his employer's rules. Mr. Gallus did this by operating a large dump truck to dump while the truck was directly underneath an overhead high voltage power line. Mr. Gallus raised the box of the dump truck 21 feet into the air, into the power line, which electrocuted Greg Hakala, who was barely touching the truck on the ground. Now, before July 16th, Mr. Gallus's boss had told Mr. Gallus to not dump while underneath overhead power lines. Ladies and gentlemen, that was a company rule. It was a rule for safety reasons to avoid injury or death, just like what happened to Mr. Hakala. Mr. Gallus did it anyway. Ladies and gentlemen, I will prove to you that Mr. Gallus was aware that the overhead line was directly overhead. This high voltage, uninsulated 8,000 volt power line was directly overhead. He was aware of it when he chose to dump directly underneath it. And despite his awareness of the overhead power line, and despite his company rule to not dump under power lines, he did exactly that. And Greg Hakala was killed because of it. Ladies and gentlemen, I brought this lawsuit on behalf of Greg Hakala's family and against defendant Stephen Gallus for negligently killing Greg Hakala. This lawsuit is also against his employer, Bex Valley Farm, under a doctrine of Minnesota law that simply provides that employers are responsible for the acts of their employees if the employees are acting within the scope of their employment. That is, if they're on the job. There's no dispute Mr. Gallus was on the job and acting within the scope of his employment in this case at the time he raised the box of the dump truck in the overhead high voltage power line. Mr. Gallus denies he is in any way responsible for the death of Greg Hakala. In fact, Mr. Gallus blames Greg for his own death. And the defendants have also sued Greg Hakala's employer, Soilcon, blaming Soilcon for Mr. Hakala's death, claiming inadequate training of Mr. Hakala by Soilcon. It's everybody's fault except Mr. Gallus. I think this is
all right. All right. Hi, everybody. My name is Sarah Soucie. I am the District 10 Justice. I'm going to be helping facilitate the discussion, and I will be monitoring the chat as well for questions. And then when we get to a little bit later in the presentation, we can just do more of an open-ended discussion. I think at this point you can't unmute yourselves, but I will change that control, and we'll come to that in a minute. But we wanted to give you guys a chance to listen to the opening statement first. Before we move on, though, I would like to take a minute to introduce our speaker. This is Fred M. Soucie of Soucie Law for the Injured. He is a humble servant of justice. He has a national reputation in catastrophic injury and wrongful death matters. He has a history of record verdicts and record recoveries for his clients. He was Minnesota Attorney of the Year in 2008 and is consistently named in the top 100 attorneys in Minnesota, as well as having been voted a super lawyer since 1994. But what I think sets Fred apart from other attorneys is his dedication to client care. You will not find someone who does this kind of work, who takes care of people and it values his clients as much as Fred does. And I'm lucky that he's also my dad. And he joined our law fraternity in the Twin Cities Alumni Chapter back in 2009. So he's been a member for several years, and we're very happy to have him. So if you have questions as things come up, please put them in the chat. I'm going to be assisting with the presentation, so we will have a section for questions too at the end. All right, so I'm going to scoot over again. So.
Thank you. I would like to thank BJ Malley, a gentleman, a true gentleman, and a scholar. Thank you, BJ, for sponsoring this talk, and Andrew, for both of you inviting me for this presentation. I've known BJ since 2009, and BJ, you've always been a very positive force for PAD. To me, you exemplify the ideals of this great organization. I was not a fraternity guy, but I am so impressed with this organization. And in part, because of you, I have been very glad. And in part, because of my beautiful, wonderful, incredible daughter, I've been very glad to be a part of the organization and active, attending meetings. And I'm humbled by the opportunity to speak to you. You can't tell your client's case if you don't know it. And you can't know your client's case if you have not lived it. You can't make your client's story come alive in a jury if you yourself do not feel it. And we have to find as many ways as possible to live our client's story, to feel our client's story before we get anywhere near the courtroom. Not just looking for the facts of what happened, not just getting down some sequence of events, that does not bring the case alive. We need to seek out and feel the human experience of what happened, the human experience of the sequence of events to bring this case alive for our fellow human beings, the jurors in the courtroom. And we need to lead with our humanity, not fancy, frivolous lawyer words, techniques, but lead with our humanity. There are universal human experiences. Everyone in the courtroom, jurors, clerks, the judge, even opposing counsel, have all felt, and you have all felt, joy, love, sadness, loss, aloneness, perhaps the worst of all, fear and terror, and pain, limitations, the tentacles of depression dragging us down into despair, and fierce anger, rage against injustice. To tell our client's story, to make our client's story come alive, we need to tap these experiences. How do we do this? I was very gratified to see that we have a nice mix of lawyers and law students in this group. And I will say to the law students and younger lawyers, I think great trial lawyers are plagiarists. We look everywhere we can to find ways to touch our fellow human beings with the cause for justice that we carry for our clients. I went to Greg and Vicky's house and I sat at his kitchen table at the farmhouse and I talked to Vicky as Greg had talked to her every morning before going to work. Greg had a big coffee cup like this. He always had it with him on a job. He always had it with him at the breakfast table. So I bought one. I talked to Vicky. I talked to his daughters. I talked to his sisters and his brothers, and the Greg stories just rolled off of everyone. I met with his mom, I met with his friends, I met with his neighbors. I walked around the farm with Vicky. I walked through the barn where Greg milked cows every morning for so many years growing up with his brother Mike. And because I had immersed myself that far, I discovered an incredible fact that was so persuasive in the liability part of the case. Because when Greg was young, Greg was scared to death of electricity, because he was electrified by one of these electric electric animal fences on the farm. And ever since then, he was scared to death of electricity. His family knew it, his boss knew it, and all of his co-workers knew that he had had this bad experience, and he never wanted to have his equipment anywhere near a power line. That was important information to have. I laid down on Greg's side of the bed, and I talked. They talked. Me very little. Vicky and the kids a lot. And I held Greg's gun. I sat in his deer stand on the edge of the woods, looking over the fields of the farm. But mainly, I felt Greg's life, and I felt Vicky's loss, and I felt his daughter's grief and despair. And that's just the beginning of making the story come alive. I think we need to learn in the type of work that I have done for victims of negligence, families of people killed by negligence, defective products, or electricity or gas explosions. It's so important that we learn how that experience affects us. Not in an analytical lawyer way, but how it affects us deep in our heart and deep in our soul before we walk into the courtroom. And I'll tell you more about that in a bit. I would like to present a portion of the trial testimony that we presented at trial. Vicky's case was tried to a conclusion. Sarah is going to be Vicky Hakala, and this is just one small but important part of the testimony at trial. Vicky, can we talk about the last time you saw Greg, please?
Okay, I guess so.
Is it okay if we all go there with you?
Okay.
What day of the week is it?
Friday.
Is this July 26th?
Yes.
Where are we right now?
We are in our kitchen at the farmhouse.
If we look around the kitchen, what do we see?
Well, we have a table, and the kitchen is open to the living room on one side. Then we have the sink and the counters and the cupboards on the other side.
Where's the table?
Against the wall opposite the kitchen sink.
How many chairs are there at the table?
4. This is where we always sit and eat our meals.
What do the walls look like?
They're painted white, pretty stained up. We've been talking about painting them this winter when Greg is off.
How about the floor?
It's old linoleum. We've actually been talking about replacing that too.
The ceiling?
It's a hung ceiling.
What color?
Off-white, but pretty yellow by now.
Are there any windows?
One over the kitchen sink.
How warm is it out?
It's pretty warm. It's been hot all week and it's pretty sticky.
What are you wearing?
I'm wearing kind of a loose-fitting nightgown.
Tell us what it looks like, please.
Well, it doesn't have any sleeves and it comes down to about my knees and it's got a flower pattern on it. It's very light and that's what I like to wear in hot weather.
Please tell us what Greg is wearing.
A gray t-shirt and blue jeans and his work boots.
What do we hear?
The coffee maker is gurgling.
What do we smell?
I can smell the fresh coffee that's brewing, and I can also smell a little bit of Greg's Old Spice aftershave.
Where's Greg?
He's sitting in the chair he always sits in on the kitchen table.
What is Greg doing?
Having coffee and talking to me.
Tell us about his coffee cup.
It's Greg's favorite coffee cup, and he takes it everywhere with him.
What does it look like?
Well, it's one of those plastic insulated coffee cups with a snap-on lid. Greg really likes this cup because it keeps his coffee hot.
Where are you in the kitchen?
Well, I'm at the kitchen counter making Greg's lunch.
Are you and Greg talking?
Oh, yes.
What time is it?
A little after 4 a.m.
Vicki, why on earth are you up so early?
I always get up with Greg and make his lunch while we visit before he goes to work.
What's that like for you being here right now with Greg?
It's my favorite time of the day with Greg when he's working construction. I have Greg all to myself.
What is Greg saying to you?
Well, he's still working over by Cambridge, Minnesota.
How long a drive is that, Vicki?
It's about an hour and a half.
What does Greg say to you about that job?
Well, he's got to do a driveway job today, spreading gravel with his Bobcat. He also tells me he probably won't get home until after 8 p.m. because they're putting in a lot of overtime.
Anything unusual about that?
No, he's pretty busy this time of year.
Vicki, in the 19 years of your marriage to Greg, does he ever not come home after a day at work?
No, he always comes home.
Does he come home if he drives an hour and a half one way to work in the morning and an hour and a half back home that night?
Yes, he always comes home.
How long do you and Greg visit this morning?
Well, after I get his lunch made, I sit down at the table and Greg finishes his cup of coffee.
What happens now?
Greg gets up and grabs his lunchbox. I get up and walk Greg to the kitchen door. Greg hugs me and kisses me.
Does he say anything?
Yes.
What does he say?
I love you, honey. Have a great day.
What do you say?
I love you too, Greg. Drive careful.
As lawyers, we can analyze things in so many ways and must to advocate for our clients. When it comes to doing our work in a courtroom, I believe we must lead with our humanity. Over the years of my trial lawyer career here in Minnesota, I've had tremendous help from my daughters, Sarah and Ruth, who from a very young age have had a very strong sense of justice. In the Hakala death case that you've heard so much about now, in the final argument, amongst other things discussed, I told the jury in these words, on Sunday morning, sitting on the edge of the bathtub, struggling with what to say and how to talk with you now about these horrible losses to the Hakala family, what it means for the daughters to lose a dad. I was talking to my wife, searching for ideas. I had hit a wall, and that sometimes happens. A wall like you hear marathoners sometimes hit. I've never run a marathon, but it felt like how that's described anyway. I mean, I was totally, completely out of steam. I was out of any reserves. But when I asked my wife how I could talk to you now about these losses for Greg's daughter, she said, let's look at the book that Sarah and Ruth gave you on Father's Day. And during the final argument, brothers and sisters, what I told the jury was that I would like to share with you from these books that my daughters have given to me. And I read to the jury probably 5 different passages. And by the time I was done, and I was not noticing this, but by the time I was done, I was relating to the jury, and I knew some of them had tears in their eyes, and so did I. I grew up a large part of my life without a dad, but in my younger years, he was a very tender and loving man and present in my life. And so I felt these losses myself. But by the time I was done, even the judge was wiping tears away, and that's not a goal. The goal is, though, to touch people. And those quotes did touch people in a way that I was struggling to find. And in my work and career as a trial lawyer, I used to hire English. This one English teacher was really good. I would explain what the situation is, what the loss was, what the struggle was for someone that lived through a catastrophic injury or serious injury, or the family who was lost a loved one. And he would search the literature, and he would come up with a great idea, handful of quotes. And, you know, if you think about it, a poet, by the turn of a phrase, can touch the deepest parts of us, I believe. And so I look for quotes in literature. I look for quotes by great leaders. And we have so many of them in the history of our nation. And great writers that are well known to people. Abraham Lincoln is a wonderful source. Remember this, if nothing else. Abraham Lincoln is a wonderful source if you do any courtroom work to go to for very salient quotes about what is just and what is true and how people should be treated in this world. Now, I learned that later in deliberations, the jury was discussing the image of how I looked sitting naked on the side of the tub. And to them, I was just a naked man, a father, struggling with a sacred duty I had to these children. Not a fancy, frivolous lawyer, but just a man. We cannot leave our humanity at the door of a courtroom. We just cannot. I love being a trial lawyer, and I love being around lawyers. And now I love being around law students too. I remember law school as this ugly place, sort of like it was a big maze, and my ego was the little mouse running around trying to figure out where the hell am I going to come out. But I really feel so blessed to have been put in the position of a David sharpening up my stones to kill the Goliath insurance companies that want to treat my clients unfairly. I would like to take a break at this point and invite questions if any of you have them before I go on much more.
Okay. So I'm going to allow people to unmute themselves, but if you want to
Drop a question in the chat too, we can do it that way.
What are we doing for time, sir?
It is 1:34 now.
Okay.
Central. Okay, you guys should be able to, if you have a question, you should be able to unmute yourself.
Can you access the questions that were submitted to me? I can get
Yeah, I can do that.
because we could start with those.
Mm-hmm.
And I have a few stories that I'd like to share with you also that just hopefully will make it so you don't have to suffer the pain that I did as a younger lawyer.
All right, so one of the first questions was, what is the biggest don't for a jury trial?
I would say the biggest don't is don't try to be somebody else. Just learn to be yourself. And that's easy to say, but I'm still working on it now at age 69. And having decades of trying cases in a courtroom, I believe I'm more comfortable in my skin, but I'm still working on digging through who I am.
Okay.
But if you try to be somebody else, sincerity is the biggest thing, I think, in a courtroom. The jury is going to choose someone to lead them in their path to a decision. And they're going to trust the one that they believe is sincere. So be sincere. Don't try to be somebody else.
All right.
Christina, I'm going to unmute you so you can ask your question. So it's a little more. Let me know if that worked. There she is.
Yeah. So how do you go about picking a storyline for a jury?
Yes.
All right. And then I'll remute you, dear, and then we'll listen to the answer. Go ahead, Doug.
I'm not sure I got the question. Can you?
Yeah, she said, how do you pick this storyline that will work best for the jury?
You know, that's a great question. Thank you. These days I'm a writer, and it's really hard for me to choose the start of a story or the title of a story, and then I'm kind of off and running. But it was the same for me doing the trial work. I would agonize about where to begin the story and where to begin the story of my client's loss. And there's an exercise that you can do where you'll need probably a few other lawyers, or maybe better yet, staff. But we used to call it, at the ranch where I went to a trial lawyer college, we used to call it finding the story. You get a flip chart and you start talking about the facts of a case, and everyone contributes and asks questions about, well, what about this part? And when people are doing this, they're not saying, what about this sterile fact of how fast the automobile is going? They're talking about the human experience of it all. But what did she feel when she woke up? What did she feel when she woke up from the collision 4 days later in the hospital? That could be an excellent place to start a story. So I think the more time that we spend searching for those parts of the case that will have a deep effect on our fellow human beings, the more effective we can be. Does that answer your question?
Yes, it does. Thank you.
Yeah, well, you got any more ideas than I do about that?
All right, I'm going to go to Ashley Owens next.
Hi there.
Hi.
In the chat, I asked if you seem to embody the total life of your client, even down to the coffee cup, which seems to be something so trivial but so impactful. And I was wondering how you, in turn, then separate yourself emotionally and physically from that connection. And does that just come with your trial preparation experience, or do you actually do things internally and externally to prepare for that?
Thank you. That's a great question also. You can tell, I picked a pretty emotional case that stirs a lot of feelings. And not every case that I tried, many of them though, many of the cases had as dramatic, not over dramatic, as dramatic as the opening I just gave you, because every single thing I said was true. In law school, they taught me to, you can't get involved with your client. You have to separate yourself from your client so you can remain objective. And it took me some years trying cases, some work, with trial organizations and seeking out, workshops here and there. But basically, I came to the conclusion that I'm never going to separate myself from my client's life. I'm never going to separate myself from the trauma of what they went through. I'm going to tap the resources of my hunger for justice for them. But for me, there isn't a rising above or separating myself from what my clients have gone through. So doing the kind of work that I've done, I've had to find ways It doesn't mean we don't have very intellectual discussions about each case, because we would. But what I've had to find are ways to renew my spirit, ways to recharge, because it does take a toll. Does that answer your question?
Sorry, she probably has to unmute
Thank you.
again.
Yes, it does.
Okay, thank you.
All right.
And when I answer a question, if anybody has other thoughts or follow-up questions to that, please, let's have a good discussion.
And we have Brother Timothy from District 23 next.
Well, where the heck is District 23?
Did I get you?
Yes. Hi. Good afternoon, Brother Soucie. Thank you so much for your discussion today and sort of building on these questions. I am a law student at the Brandeis chapter at Washington College of Law at American University.
Oh.
And so I'm going part-time, and so I haven't taken trial advocacy yet. But in rhetoric, like, it was something I found that I definitely struggled with in blending the emotional narrative that you've done so well in demonstrating today with the legal elements. Like, my professor, and the feedback I got so much was I was very clinical and precise about the hypothetical and that, but really blending and weaving in that narrative was something I definitely struggled with. So if you have any advice as someone who is a law student on how to do that more effectively, it's just been something I feel like I've been kind of bumping up against.
Okay, and if I understand, what's your first name?
It's Timothy.
Hi, Timothy. And whereabouts in the nation are you located? Washington State or Washington?
DC.
Okay, thank you. So the question is how to not just do a sterile presentation of facts. Is that right?
Yeah. Like, what are you looking at when you talk about embodying, the victim and the family and that experience? But it was something I guess I found I struggled with the hypotheticals that we dealt with in matching that, because it was like I was so focused on the legal elements and trying to prove that in the writing, especially, was to translate that more into that narrative so it is more compelling.
I think, was the hypothetical that you were dealing with, did it involve a real human loss or someone's freedom?
Yeah, it had, one of them was related to employee negligence. We had an electric scooter that injured a young girl selling lemonade on the side of a road.
Okay. When I've been in a courtroom, it's always been on the side of the equation where a human loss has been suffered. Now, sometimes there's human loss on both sides. Sometimes a drunk driver takes out my client, but their life is destroyed too. I think the best way early on for me, kind of a bleeding heart from a JFK, Democratic family growing up as a kid in Elgin, Illinois. But one of 8 kids, do you think my parents were Catholic? Yes, they were. So it was sort of easy for me in a way. But there are different places that you can find about the courtroom. Some really good books written by well-known practitioners, but practitioners who've done the kind of work that I have done, and I would highly recommend for you. I wish I had a title for you now. I'll try to get one to Sarah to spread later. I think one of them is The Whole Man by Mo Levine. And it might even be a 48 book. It's a classic, and it's a wonderful book to read. And it's Mo, who back then nobody was getting any decent verdicts in injury cases. It just wasn't done. But he started down that road, and he started by leading with his humanity. I would highly recommend that book to you. In terms of getting in touch with how things affect us, I mentioned, I think we need to see how the case, how the loss is affecting us deep inside. And I was getting ready to try the Hakala death case and another death case for a fine young man named Terrell, who was hit by a car that came over the center line. His fiancée was 2 cars behind and got up to the passenger window, and he was able to pick his head up and look at her, and then put his head down and died. But those death cases were very troubling to me. And Terrell's father, Jim, had responded to the loss of his son in a way that was, it's going to sound disrespectful, I don't mean it to be, but self-pitying. He was, this sounds disrespectful too, but he truly was wallowing in his grief and not moving ahead with his life in the least. So I talked to my partner, Dave, about that, and I said, you know, I'm concerned that this could alienate the jury. What do you think? And he said, well, just, you know, put him up there. He doesn't have to be there very long. The jury will understand how terrible the loss is, and then, you know, get him off the stand. And I talked with someone that I consulted with a lot on trials, and also with my own life experiences and trauma. And she's what's called a psychodramatist, and I would urge you all to just Google psychodrama and see what you come up with. That's made more of a difference in my life and my success as a lawyer than anything else. Law school, seminars, talking to groups, listening to lawyers, reading books, or anything else. But Caitlin said, you can do that, Fred, but if you do that, you will lead the jury away from Jim. And as soon as she said that, I knew she was right. And it turns out that I was still grieving the death of a 13-year-old boy. The boy had flashed in front of my Suburban on a back street of our town of Anoka, midnight, no reflectors, black clothes, black bike, and was kind of being a daredevil, and he died. And I was so grieving that death in my own life that I was not really capable of representing my clients for the loss of their father and husband in one case, and son and brother in the other one. But I did a psychodrama just on little Dan's death. That's how he has become known to my family. He attended school with Sarah. It was a very traumatic time for our whole family, but thankfully, before I walked in the courtroom on those 2 cases and acted as though I couldn't deal with the emotions and the losses in the case, I figured that out and did some more work in a psychodrama devoted just to me experiencing this accident again, except inside the psychodrama becoming little Dan, the 13-year-old boy, and daredevil who had died. So anyway, I'm not sure if I'm wandering or answering questions now, but I think it's important to see how things affect us and get in touch with them if we're going to do work on serious losses.
Okay.
Thank you very much.
Yeah, you're welcome.
All right, next we have Kai Shah. No, whoops. There we go. Did I get you, Kai? Okay, there we go.
Oh.
There we go.
Okay.
Hi, is it working? Can you hear me?
I can hear you now.
Hi.
Hey. Okay.
Yay. Oh, by the way, you guys are doing, I can't believe you're doing this convention as well and with as many participants as you are. It kind of blows me away. Now, Kai, what do you want to ask me?
Hi, I'm a law student going into my 2L year. I just had tryouts for mock trial. And I guess my question kind of goes off of what Tim was asking, is that you took us through like this great narrative of going to your client's house, sitting on his chair, drinking from his coffee mug. How does that work? How do you get that level of like emotion and detail when you're doing a mock trial and you have like these hypothetical clients? Like, how do you connect with them on that level?
Thank you. I think that's a great question for all of us old lawyers too. But I don't think you can, because it's not real. I think that you can, try to imagine if there's a serious loss involved, but I don't think you can invest emotionally in something that for you cannot be emotional. In this case with Greg, not a single thing I said was acting. Not a single thing I said was not felt deeply and truly by me. And that was my huge rule for doing my work this way. I know there's some seasoned lawyers involved, and I have had the question asked of me from time to time, do you get away with that in a courtroom? And I have never, ever had a judge sustain an objection when I've done an opening like that, because every single thing I said was not only true, but was going to be presented to the jury. Keep talking to me about that question. I think the best that we can do in the setting that you're in is get involved hypothetically, and you can try to reverse roles with your hypothetical client, where you become the client. When I was at a month-long trial lawyer college in Wyoming, out on the ranch of a fellow called Jerry Spence. I would highly recommend his books, by the way, to anyone that wants to be a trial lawyer of any type, Jerry Spence. And I learned techniques about reversing roles, and not just with our clients. If you think about it, in reversing roles, we try to become the other. And you try to think like and really embody the person that you're switching roles with. And I have a secret for you. It really works great if you have a conflict in a marriage. And you can truly do it where you reverse roles and become the other person and speak as that other person. I would recommend that we all try to do that, not just with our clients, but with other witnesses, with the judge, for me, insurance company lawyer also, and the insurance company, I paid expert witnesses against my clients. I'll try to just figure out where they are really coming from, not in a judgmental way or in an angry way, but just in a real way. And it cannot help but empower you. Now, I see that my pad sticker is really kind of iridescent there, so I'm sure it's distracted everybody from everything I've said. Did I answer your question?
Yes, you did. Thank you so much.
Yep, you're welcome so much.
All right, I got a question in the chat that says, can you tell us about your first trial as a young lawyer and what you did to prepare for it to overcome all the things you didn't know about being a trial lawyer? And I know that it says that came from me, but I swear I didn't plant it. I just...
Believe it or not, my first jury trial as a young trial lawyer was for my then mother-in-law. Now, the fact that we lost the case, could that be why her daughter and I divorced? God forbid, but I don't know. Maybe it was not a real strong case when you look at it objectively. From the point of view of being a slip and fall case outside of a holiday. And entrance where there were rocks on the dang sidewalk that she tripped, and she had a serious enough hand injury. I'm trying to remember how I prepared for that. I know that I went to as many of our local Minnesota Trial Lawyer Association seminars as I could. And one of the things I would highly recommend for all of our law students and younger lawyers, and I still am a mentee. I mean, when there's something that I want to bounce around, I bounce it around with not just grizzly old guys like me, but with younger lawyers to try and get a different perspective. There are workshops, I believe still workshops through the National Association for Justice and probably for the Defense Lawyer Association. I don't know if any of our members can speak to that, that I went to when I had several large cases that I was going to be trying, and the partner in my firm that did personal injury work didn't try cases. He was afraid of the courtroom. So I had to learn it on my own. He's a wonderful guy. I love him dearly. If he was here, I'd kiss him on the forehead. But I went to this week-long workshop, and the first day, a nationally prominent trial lawyer talked about jury selection. Then we broke into our small groups and we talked about it, and then we videoed ourselves. I know we have someone named Ron listening, I believe, that teaches trial advocacy as an adjunct professor, and he had the beauty of a 3-day workshop. But we would have one part of the trial and a full day devoted to it, and really deeply engaged people giving the seminar, teaching the seminar, guiding us, whatever you want to call it. The next day it was opening statement. We had a wonderful opening statement, and we talked about what goes into it. You know, they give you a manual too, so you can read that. But I highly recommend something like that. And by the time you're done with a course like that, you handle each and every different part of a trial. And damn, I had forgotten about that case I lost from my mother-in-law. Damn, but it helps tremendously get comfortable. And there's something else that helped me very effectively when I was a young lawyer. And you know, when you walk in a courtroom, you don't know what you're doing, right? Or you think you don't know what you're doing. But the biggest thing is you think that people looking at you think you don't know what you're doing. That's complicated, but I would highly recommend something I call a trial notebook. And I can't take credit for originating this. There was a lawyer named Vern Lawyer that I heard at a ATLA seminar many years ago, and it's called Trial by Notebook. But look it up. Get hold of me through Sarah if you want a sample of it. I'll be happy to send a pretty good sample to anyone and everyone. In the front of a trial notebook, and I like it to be a 3-ring binder, there's the master to-do list, and everything that I remotely think of that needs to be done gets on the master to-do list. Then we have a section dedicated to voir dire, and you know, you set this up when the case is a month old in your office, and then every time you think of a single thing, oh, you know, on the Jones case, I got to ask these jurors if any of them have had a friend that drank so much the night before he had a 0.20 at 10 in the morning, you know, like in our case. So I would say put that in the voir dire part. Then I had an opening statement thing of things that I really wanted to make sure I covered in opening statement. I've got a form for direct examination of our witnesses, and it's wish I had one here. And just get hold of Sarah.
Yep.
And actually, I bought notebooks for $150 a piece that were legal size because I was a lawyer. So, but I had a page for our witnesses, and there's a line down the middle, and there's lines, and I would write the question I was going to ask our witness, and then the other side was anticipated objections and authority. So if I asked the client something that on the surface could be deemed hearsay, but obviously is an exception, I'd write the question here, then I'd write the rule, the black and white rule, but also case law that might be relevant right there. And if you try your cases like that as a young lawyer, it really, you can look like you know what you're doing. And if you take that time, you do know what you're doing. I'm really going on, but ask Sarah, anybody that wants, ask Sarah, and we'll put together a package for everybody to see.
I bet we can get it in the pad library too. So I'll make sure that we do that. Yeah. Everybody's excited about that. Okay, Kelly, Sister Kelly from Magruder Chapter, you're up next. Then we got a couple more after that too.
Hi. So Magruder Chapter's in Champaign, Illinois. Nice to see another Illinois face.
Thank you for orienting me.
But that way you have an idea. One of the things that I've found to be a bit of a struggle is depending on where you decide to practice, how do you adjust your style and your approach based on your big city folks who have an expectation or one style that's expected versus your small town, your rural folks who what you would do in the big city wouldn't fly there? How do you make those adjustments, especially in terms of storytelling for your openings and witness preparations and working with the other side?
Thank you. That's a great question. Tell me a little bit about yourself. Are you a law student or a young lawyer?
I'm a second-year law student, but I've been doing mock trial for years. But I grew up in Springfield, so I'm a person who grew up in a capital. But you have Chicago and St. Louis, and I'm sure you know the dichotomy between central, southern Illinois and basic, really rural anywhere else in the Midwest. Rural Midwest and big city Midwest.
Yes.
Kind of that dichotomy there. So I'm wondering how you've learned to navigate that, if you've navigated it at all.
Thank you. Great question. And I just want everybody to see that this is my pad gift. It says pad.
Make sure you tell Andrew he was using his.
Andrew, thank you again. Yeah. And Emily. Okay. For me, it does not matter where I'm going to be. I don't try to tailor things if I'm trying a case in Minneapolis versus northern Minnesota. Sometimes the only thing, I just don't do anything differently at all. I think find our center and our most sincere advocate for our clients, and bring that with you wherever you go. That's what I would recommend. I was trying a wrongful death case in northern Minnesota for the family of a Native American girl who was 6, Brianna. She got out of the school bus, was crossing in front of the school bus like she was supposed to, and the school bus driver ran over and killed her. And there I was in a rural setting, small town, Walker, Minnesota. And you got to figure out a way to deal with being hometowned by the lawyers in that community and the judge in that community. And so that can happen. In my case, I think the judge probably grew to first really dislike me when he said, he said where this lawyer was from, the defense lawyer, and then he said where this other lawyer was from, the other defense lawyer. And then he looked and said, and Mr. Soucie, and he kind of goes, "You're from somewhere down in the Twin Cities, aren't you? Give me a break." But I stood up and said, "No, Your Honor. I'm from Anoka, Minnesota, just a little ways north of Minneapolis there, then." And the jury loved it. I don't think the judge liked it that much, but He was overly serious anyway. And I don't want to get started on that, Judge. I love judges. I mean, judges try so hard to do a good job. Have I answered your question, or am I just rambling again? I would just be yourself. That's the big thing, is just be yourself in whatever environment you find yourself, please.
All right.
You got it. Thank you.
You're welcome. Thank you very much. I wish we were at a convention where we could talk tonight, everybody.
No,
You know?
there's so many. Yeah.
Yeah.
All right, Brother Milgram, it's you're up next, sir.
Okay. Actually, I have two questions, but I'm going to focus on the first one. I'm Glenn Milgram. I'm District 21 Justice. I am a trial lawyer per se. I haven't had that many trials because, like all good lawyers, we try to settle as many of them as we can. Also have to be aware I do mainly family law, so there's a lot of mini trials, so to speak. So it's a different perspective. However, my big trials that I've had before juries are usually construction cases. And defective construction more than anything else, or questions with regards to violation of property rights, such as easements and all the fun-loving things that you could dream of. So obviously, emotional aspects don't come into play very often. So I'm going to ask you the question that I asked you before the session started, which was the second question on the Q&A list, which was, at what point do you skip making valid objections because you believe you're starting to annoy the jury? Are you better off making the objections to preserve the record?
Yeah, I think that's a great question. And it's along a technical line. I just don't, there's emotions involved in terms of emotions with the jury, maybe the judge, but our own emotions. Are we looking, acting, behaving in a way that's going to turn the jury off? So, and I think what I tend to do is I'll approach the bench. Generally speaking, I don't like speaking objections, although my opponents over the years have done it kind of relentlessly in court, where then you say, Your Honor, may we please approach and say, Judge, you told him no speaking objections. He keeps doing speaking objections. If he does a single other one, I'm going to ask you to admonish him in front of the jury. And then I look at the guy and say, can you pretty please just quit doing speaking objections? But in terms of turning the jury off, the objections that we can make, you have to state the basis or you lose it, right? You have to object in a timely fashion or you lose it. I mean, that's all the court rules that I know, federal and in Minnesota, other states where I've been. And so a simple, objection, irrelevant or objection, lack of foundation, I think is a necessary thing to do, whether you're alienating anybody or not. You don't have a record that you would need if prejudicial stuff's coming in. I know what you're talking about, though, because I've had cases where, the conduct of counsel has been so bad, but if you call for a recess, you can discuss this and put on the record, Judge, this line of questioning is not right. I don't want to sit here and object 50 more times. If you sustain an objection, either he needs to move on to a different topic or be admonished to move on to a different topic. The other thing is, under certain situations, you can preserve making a record. I never make records on objections in the hearing of the jury. I always do it outside. And so during a recess, we can set up, I want to make a record, Judge, on blah, 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 blah. And, they cannot refuse you, even if they're not the greatest legal minds. They have to do it. It's part of our rules. Does that help at all?
It explains some of the things. I know I practice in New York and New Jersey, and we have very limited time for our trials. The judge will say, okay, you have 3 days, or you have 2 days, or whatever it might be. The longest trial I had was 5 weeks, which was
That's a killer.
painful for the jury. And we realized towards the end that it was very painful for the jury, and we tried to lessen our objections and other aspects as much as we could. The other question that I had for you is, you seem to be fairly dramatic in your presentation. When I say dramatic, I mean you're hitting on the emotions. Whereas, like in a construction case, it's all technical, and how do you explain to somebody, how do you approach things in a technical way that the jury can understand, but still trying to keep it on a level where they could relate. Like, instead of talking about the building of a house or somebody expecting a mansion, I would possibly relate it to a car. You know, they wanted a Cadillac, but they only got a Toyota. Something to that effect, to try to get them to relate it to something personal that they might understand. Because not everybody lives in a house. Not everybody understands how many steps there should be in a staircase, or why a staircase should be in a certain location. It gets boring. So I was kind of wondering, how do you know when you've gone too far with the hand gestures, facial expression, looking up to the sky and say, oh, let me think now. You know, how do you avoid doing things like that? Or do you try to avoid doing things like that, I should say?
Yeah, I don't. As long as I'm being sincere, I'm comfortable with my presentations to a jury. I did have a judge one time, I'll share with you. We were in court, we were on a motion because the power company lawyer wanted to get at my client's juvenile criminal records, which is a verboten. You know, we make mistakes as kids, and it's supposed to stay confidential. And so he was really coming down hard, and I don't know how many motions we had in that case, but I was just cutting my teeth. I was a very young lawyer, and he was with a silk stocking, big downtown firm. But he said during the hearing that I was, what's the word for really hard litigation, scorched earth. He said, and Mr. Soucie is doing scorched earth litigation, and he is harassing blah, blah, blah. So when it was my turn to talk, I said, Your Honor, how could a little old lawyer like me in a little bitty law firm of 4 people in Anoka, Minnesota, harass one of the biggest power companies in the nation? And she said, cut out the theatrics, Mr. Soucie. And I said, Your Honor, I don't have a theatrical bone in my body. And she picked the gavel up like I was going to get hit with the gavel, and she tried to look real stern, but she had to laugh. So maybe I would defer to you in terms of advice and counsel on trying those kinds of cases, just because I never have. I really would defer and vouch and respect you and your experience on it, much greater than mine.
All right, next we have Sister Ramitz from, let's see, where's Lindsay? There you are. Okay. There we go.
I'd like to know what your thoughts are on the reptile theory. And here's where I'm coming from in asking this. So I do civil litigation. I've had a number of PI cases, decent sizes, nothing just huge. But I have a couple that are probably going to be going to trial, if I had to guess, probably about 2 years from now. Talked to a couple prominent Dallas PI lawyers who have nothing but great things to say about reptile theory. I've researched it. It seems like a rather cumbersome undertaking. And so I'd kind of like to know if you think it's worth the time and expense, or if it's just your thoughts in general on it.
Okay, if it's okay, let's tell everybody what we're talking about. The reptile brain is a reference to our ancient brain, the survival, the fight or flight, right? That's what you're referring to?
Yes.
Okay. And then we have the more later developed frontal lobes, which are judgment lobes, intelligent lobes, and this and that. And I have heard and read and attended seminars from people that say, we really have to touch the reptile brain of the jurors in order to win, right? That's what you're asking about, right? Yeah, okay. And so I think that it's very worth reading. I think that attending a seminar, why the hell not, in terms of getting ideas. But I think as a younger trial lawyer, I just wanted something other than all this frickin' gray that was swooning around me all the time. I wanted a clear cut, okay, let's do this, and then, I'll be a good trial lawyer because I'll have done that. And so what I would say is expose ourselves to it, sure. Don't let it become a mantra, unless it feels right to you. I wouldn't let it overwhelm other things that you are learning or interested in as you go along. Are the cases of a size that you could consult with a trial consultant person?
Probably not I could probably team up with another personal injury lawyer in Dallas. Yes.
Okay, well that's not so bad, and you kind of learn it as you go. When I was doing cases, my partner that did PI cases, I was an associate that came on pretty soon. I was trying cases with much bigger recoveries just because he wouldn't go to court. But I think that's one great way to do it. Another way you can do it, though, is to find out when and where people that you respect are going to be trying cases, and sit in the back of the courtroom as an observer. And even with trials under my belt, I always learn something. Always learn something doing that. And you know what? When you're sitting in the back, you realize all the things they're screwing up at the bar because you're not there. You're not the one with all the stress and pressure under you. But I would really, really highly recommend that become active in your. Dallas has a Dallas Trial Lawyers Organization, I think, right? Yeah, that'd be a good spot.
Your son-in-law says that you were doing the reptile before that was a thing.
Oh.
But he also suggested the Rules of the Road and Polarizing the Jury books.
Oh, okay. I'm not sure. Yeah, I haven't read those. But let me think. I guess if you can find someone that you can call from time to time with a question that doesn't mind mentoring. Do you have anybody like that right now?
Yeah. So I have tried quite a few cases, and I've gone, but like I said, they've all been smaller PI cases, not ones where there's 7 figures on the table. No. But I've even worked with co-counsel on some smaller cases, but I feel like I'm getting to the point where I could probably get out and do it on my own.
Amen. Go for it. You go. Excuse me. You go, girl. I'm going to say you go. I usually say, and I have 7 daughters, but you go. I mean, really, truly, you go, sister. And one thing that you could think about doing too is if you have someone that you're very comfortable with that could second chair you, in terms of just making that next step more comfortable, do that. But otherwise, you go for it. You get the trial notebook, and then everybody will think you know what you're doing.
Yes.
Yeah, let's see.
Thank you.
Thank you very much.
I have, let's see if does anybody else have a question that is burning? Otherwise, we've got a couple more in the chat that we haven't yet. Okay, I am gonna go ahead. There's a question that asked if you have, and I know you answered this, but for everybody, given the choice between a physical demonstrative aid, a video reenactment, or oral summation, which do you pick?
You know, since I started way before you guys, it was always, I'll show you one from the Hakala case. I don't know if you'll be able to see this. Yeah, I think you can. That's a picture of what Mr. Gallus said our client did. And it couldn't have been an innocent misstatement. It was an absolute fabricated lie. And then this was where we raised the dump truck into its fully elevated level, and we photographed and measured from where the contact marks were with the high voltage line and the steel. It made little welds, and the ground, just to further document the facts of the case, because Greg was dead, and the only witness started blaming him right away. Mr. Gallus was the only witness, and he started blaming him right away. So I love these. I don't, in a case like that, if I were going to try it again, I think I would have those because they can go back in the jury room. I think it's a lot harder to go, back in the jury room and then start tapping computer keys. So keep that in mind. You want to have some paper exhibits, even if you do some of this up on the screen. I've done complicated medical testimony. I think is greatly aided by having a big screen right next to the jury and the doctors in the box next to the screen, next to the jury. And we'll have blow-ups of x-rays, in one of our cases for Ron Jones, more dramatic than anything I could see. I mean, his arm was pulverized. He was taken out by a drunk on a Saturday morning at 10 a.m., still drunk from the night before. And his left arm kind of looked like Wheaties, it was really, really so bad. But I like a mix, and I think there's different things to consider, but try to always reverse roles with the jury and see what you think would be most helpful to them, because if it's helpful to them, then it's effective as far as I'm concerned. Did that answer it?
Well, I think that was from
that was okay.
From the forum. So anybody else have a question? And if not, we've got more too. Let me see.
Well, I have a story.
Okay, tell the story.
I have a story. Jeepers, I don't know if I've been trying cases for 10 years, something like that probably. And I had a case for a nice man in the 60s, Sally Marcellus, and he was driving down the freeway in Minnesota, and a dang semi moved into his lane, hooked his car, and then sideways pushed him down the road. He had injuries that were what litigants would call soft tissue injuries, nothing really great, but it ended up costing him his job because he just couldn't do his industrial electrician work anymore. The defense attorney was going to inquire about my client's retirement plans to show that he had an incentive to, who cares? He's stopped work. He's got this financial security. And the case law, controlling case law for us and controlling case laws for most of Minnesota was you cannot inquire into a person's retirement plans. We work our whole freaking life to put those things aside, and as a society, we're not going to allow them dipsy-doodling around with that unless the client says something like, well, I can't afford, or I can't afford this or that, and then it can be used as impeachment. And the judge made the wrong call on that. God bless him. He later became our chief federal judge in Minnesota. He's a wonderful man. But he made the wrong call on that And so I'm still trying to argue. One thing to keep in mind, you got to pick your battles. If you're going to go to the mat more than once on an issue, don't do it on every issue. Don't let your ego dictate it. Let what's going to really hurt your case or what's going to really help your case be the focus. But anyway, he was, I wanted then to get a limiting instruction from the judge. And I wanted to know about it before my client was cross-examined by Mr. So-and-so. And so I asked to make a record. And the judge came out, and he was on the bench, and the jury wasn't there, and he was grumpy. And he said, "Mr. Soucie, you have a record to make?" I said, "Yes, Your Honor." And I laid it out. And he said, "Mr. Soucie, you've argued this before, haven't you?" "Yes, Your Honor." "In fact, you argued it in your trial brief, didn't you?" "Yes, Your Honor." "Then you argued it in chambers, didn't you?" "Yes, Your Honor." "And I ruled against you both times, didn't I?" "Yes, Your Honor." "So why are you bringing this up another time?" And he said, not quite that mean, but, and I said, "Well, because, Your Honor, you're entitled to a second chance." And then he picked the gavel up, and then, God bless him, he kind of stormed off the bench. He came back out, the jury was in, he came back out without his robes on and said he wanted to see counsel in chambers, and I'm going, oh my God. But God bless him, when he sat down, he said, "The court is concerned it's making a mistake. And I want to go over this again," and he did. And he said, "You'll get your limited instruction," which really wasn't enough, but better than nothing. And then later, he had his clerk do some research, which I had provided him right away anyway. And he totally changed it and said, "You can't talk about this." So justice prevailed. And we got a nice verdict.
Awesome. We've got like 2 or 3 minutes left. So if there are any last minute questions, we can take them. Otherwise, if you have any parting thoughts or other good stories to tell.
Yeah, I got one. For law students, remember this when you're a young lawyer. I've handled a lot of giant cases, and of course, sweat bricks the whole time doing it. But in a lot of large cases, explosion cases, electrocution cases, I was in a room with 8 defense attorneys one time at the beginning of a case, and I asked this simple question of the lead witness for the power company, who was an engineer, and there were 8 objections. And so that's a piece of life, or you can have it as a piece of life on large cases. I learned from a wonderful man that I got along with like this for the first 32 depositions in the case, because he would object and instruct his client not to answer, and then I would argue about the rules, and we never got anything done. But finally one day I said, "All right, Blanchard, what's wrong with that question?" And he said, "Well, Fred, since you asked," and he told me what his concern was. And I said, "Oh, I can address that." And I did. And I got the information I wanted without arguing about the rules, getting my ego out of it. And I was helping the lawyer on the other side, like all of us good civil people should do, right? And if you think about it, from then on, when I got an objection, I said, "Well, tell me what your concern is. I'll see if I can address it." What are they going to do? Say no? I mean, say, "No, I'm not going to tell you what my concern is." I'm going to say, "Come on, I can address it." I did have a few lawyers do that, but not very many. And my deposition life became so much more genteel and effective by just saying, "Well, tell me what your concern is, and I'll do my best to address it." How do you like them apples? I hope it works for you guys.
All right, I think that's us right at time, unless anybody has one more question.
Yeah, I mean, I can stick around, but it's up what you guys are. I mean, I got all day. Anything else? I was going to tell you a brilliant time travel joke, but you didn't like it.
Jeez. Sorry, I have to check like 3 different chats. Everybody's really excited about the trial notebook, so I'll make sure to get one of those there. But if you guys just want to unmute yourselves and chit chat for a little while, I can switch to gallery view, Dad.
Yeah, anybody wants to chit chat. I just love this. Thank you so much for having me. I hope that it was of interest and so on.
Yeah.
Well, thank you. I do have one question for you.
Yes, please.
And I hope it's appropriate for everybody in the room. When you have a jury trial, do you dress for the court or do you dress for the jury? Because the one thing I was taught is a judge will never remember your suit, but they'll remember your tie. And so invest your money and buy yourself good ties. And so I was wondering whether there's a different approach for the makeup of the jury. You come from a different region than I do, so things may be a lot different.
You know, I for kind of a role model in a lot of my life, I located a hero called Jerry Spence out in Wyoming. He's written some great books for any of us young law students or lawyers interested in fighting for justice in a courtroom. But I really related well to what he said. You know, he doesn't want people looking at his clothes. He wants them looking at him. And so I always kind of dress plain. Not when I'm addressing highfalutin fraternity, however, like you guys, which I'm honored to do, you know, or sometimes in depositions, depending, although I've worn T-shirts to depositions also. So I'm not the best guy to say because I usually dress down. And I like dressing down and being next to a $2,000 suit most of the time.
No, I learned my lesson as a young lawyer because I used to have a lot of these Disney ties, and I walked into a courtroom once, Mickey Mouse on it, and the judge wasn't very pleased.
I don't
comment.
think I'd recommend a Disney tie. Really, truly, I wouldn't. Okay, Wendy, where are you from? You must have it. Where's the weight chapter?
I'm from the University of Dayton, in Ohio.
Oh, cool.
Yeah, I actually live in Florida, though. So I'm coming from Florida, but I'm a hybrid student at the University of Dayton. So I get to study right from my home.
That's nice.
That's really nice. Yeah.
I switched to gallery views, so it's going to be like law school class, and he can see you now.
Yeah, like a zoo
Call
book.
on you,
Like a
so
zoo
just
book.
be ready. I like to say thank you to everybody too for coming. I was really excited. I was so hoping that we would be in person and I would get a chance to share all of you with my father, but also my father with all of you, because I know you guys are the kind of people that would be his people very much. And for anybody who is a first-time attendee for convention, you know, this is obviously unusual times, but I do hope that you come to some of the things in the evening as well, so you can get to know our folks better too.
BJ, are you still there?
I don't think BJ, the IEB, we put them through the ringer this morning, so I think that they had
Okay, didn't make it. That's fine.
Yeah. But
I'm happy to stick around if anybody wants to ask any more questions.
Yeah, we don't
but
have the
if you
next
can't-
session, and
Yeah.
we don't have the next session till 3.
Yeah,
so.
it'd be fun. I would enjoy it if anybody has any interest.
Yeah, but if people have to drop off, go ahead.
Yeah, if people got to drop out, that's fine. I just so much of a trial lawyer's life, as far as I'm concerned, is a spiritual, emotional battle, and I kind of referred to that a little bit in one of my postings, and it's the kind of thing that I think as law students and young lawyers, well, grizzled old lawyers like, where'd my buddy go there? Glenn, you and I are we're grizzled old lawyers. But one of the things that I found myself wrestling with was always, you know, self-worth, self-value. Is the jury going to reject me? Is the jury going to love me? Are they going to hate me? Are they going to love my client? You know, and those are really heavyweight kind of things if you take this kind of work seriously. And I think I should give a seminar someday about not taking it quite as seriously as I did for decades. But does anybody have any questions like that? My dad was an alcoholic. I'm an alcoholic, been recovered for 4.5 years, but that's a trap that we can all fall into very easily because we're so stressed as lawyers and law students. I mean, what a pain in the butt that was for me back then. But
maybe you could help by telling people how you control an emotional client that you're sitting next to when they hear things that they don't like.
Oh, that's a good one. I was let me rattle that one around for a little bit, because the story I have to tell you is a little bit off center on that one. But
well, do you pass them a note? Do you kick them in the ankle? Do you call for a recess? I mean, what approach tends to work when you have a jury in the room?
Yeah, I guess you can ask for a recess. In some cases, not too many, because I usually ended up in court with clients that I loved. Not always, but I think if you had I'm trying to remember a code word that I used with this one client when she was getting snippy rather than. There's such a. Try this. I had clients that would speak in anger, and then I had this example to drive home a point with them. And I was in an airplane crash in 1980, herniated disc in my neck. Have been through this as a plaintiff, but I'd tell that to my client, and I'd say, I want you. I went fishing over the weekend, and I want you to ask me how that went. So somebody asked me, how did your fishing go over the weekend, Fred?
How did your fishing over the weekend go, Fred?
I hated it. Every God blessed time I'd pull the rope up, I'd get spasms in the back of my neck, spasms in my low back. I hated every second of it. That God blessed airplane crashes ruined my life. So that was one example. Now somebody asked me again. It has to be you again.
Oh, okay. How was the fishing this weekend?
It was horrible. I mean, I've always been strong. My whole life I've been strong. I lifted heavy weights, played college football. Now I can't even pull an anchor off the bottom of the lake without terrible pain, without spasm. And then I can't. It's hard to sleep that night. It's just turned horrible. Now, which of the two would you relate to? When you think about anger, it's the exact opposite side of hurt, right? I mean, it's true. And I taught my kids this.
Yeah.
When you're angry, look at how someone's hurt your feelings, because that's really what's going on. That was a lesson that I used with clients, many times over the years, if they were going to speak to anger, and I would not blame them. I had a client burned over 90% of her body terribly, and she was angry, and she deserved to be angry.
My question was the witness that's sitting next to you who hears testimony they don't like. Technique I used was I just hand them a pen and say, write it down, so that they're not showing it on their face. Because the jury watches the person the entire time.
Yeah, they spend a lot of time looking at our client and us, don't they?
Yes.
Now, a guy as handsome as you doesn't have to worry about that. But when they're looking at me, don't look at me. Look at my client, please.
You become very conscious of everything that goes on in the courtroom. And I think that's a problem a lot of the people are going through with the virtual meetings and possible trials with people wearing masks. Because you're not going to be able to see all the facial expressions.
Yeah, I like the fact, truly, though, that, you know, I think the eyes are such a communicator, and you can kind of tell what's going on under the mask. If someone is smiling, or if they're real serious or sad or joyful, just by their eyes. So thank goodness masks don't cover our whole face.
Yeah.
Does anybody have a joke for me? I mean, I gave you the time travel joke. I could use one to go with the day today here.
I don't have any good jokes.
Well, thank you very much for including me as part of your convention this year.